Welcome to the Timothy A. Jalot Dialogue on the Rule of Law in East Asia. I'm Catherine Wilhelm, Executive Director of the U.S.-Asia Law Institute at NYU School of Law. The Jalot Dialogue is our major annual conference on rule of law topics that are particularly salient in Asia in any given year. The dialogue is named in honor of an American lawyer who was a practitioner in China in the 1980s and 1990s, and also taught at NYU Law. It's usually an all-day event. Last spring, we had to cancel our Jalot Dialogue just days before it was scheduled because of the pandemic, but that was before we had met Zoom. This year's virtual Jalot is taking place over 2 days. Today's panel will talk about Asian supply chains and human rights, and tomorrow, starting at 10 a.m. Eastern Time, another panel will discuss the ethical dilemmas of the China scholar. And in a nutshell, that means various aspects of academic freedom in the context of China studies. Out of all possible human rights topics, why did we choose to focus on supply chains and academic freedom? Because these are two places where the ideas and the ideals of human rights intersect most closely with our own daily lives as consumers and as scholars. Our goal for today's discussion is to talk not only about the problems, the challenges, but also responses that might help make a difference in ultimately addressing the challenges. Responses that to some extent are within our grasp. Each of the panelists will share his or her insights about how to respond to human rights problems in the supply chain, what experience tells us works, and what we have not yet tried, but should try. The panel is going to be moderated by USALI affiliated scholar Aaron Halegua. Aaron is a scholar lawyer. A big part of his legal practice focuses on labor law, including labor trafficking. He recently assisted over 2,400 Chinese construction workers who were trafficked to Saipan recover $14 million in back pay. And he is currently litigating a case in US federal court to recover compensation for some of those workers who were injured on the project. He also writes about labor issues with a special focus on labor rights in China, and recently published a paper exploring the rights that Chinese overseas workers have under Chinese law for any injuries or breaches of contract that they suffer while they're overseas. So with that background, Aaron is the perfect person to lead our discussion about this complex subject. Aaron, thank you for joining us today. And now I'll give you the microphone and let you take it from here.
All right, thank you, Catherine, and good morning to everyone out there. Welcome to NYU, or NYU, and our panel on Asian supply chains and human rights, a topic near and dear to my heart. I'm going to make an assumption that the people who got up, opened this Zoom, clicked on the link, previously registered, are already familiar with the topic and the subject of the panel. It's not like sometimes when we're on campus and you have a few people who stumble in mostly for the free cookies and the wine and cheese and might not really know what's really being discussed. I assume people who are here at 9 a.m. Know that we're going to be talking about human rights problems that are generated or linked with sort of the global supply chains that are anchored in Asia. And today we really want to focus on what are some potential solutions to these problems, right? We're talking about worker abuse in factories, sort of pollution and other environmental abuses that happen. And of course, I think front and center on a lot of people's minds are recent events or not that recent, but developments in Xinjiang and, right, what kind of responses can different actors in the system have to things, to problems of that sort. And so we have three wonderful experts with us this morning, all people who I did know prior to this panel, but probably the first time that I'm seeing them in any capacity since the start of the pandemic. So that's a nice treat as well. They have extensive and impressive bios. Because I want to sort of get to the heart of what they have to say, I'm gonna allow people to sort of read those on their own. I don't know what order they're appearing on your screen, but in terms of the order that they'll be speaking, Scott Nova is the executive director of the Workers' Rights Consortium. And as we get into his prepared remarks, we'll talk a little bit about what WRC does. Zhang Qingjing is the executive director of the Center for Transnational Environmental Accountability, which I believe is based at the University of Maryland, or if how those all fit together, she can help us understand. And then Mei Win is an assistant professor of law at Temple University Beasley School of Law. And she, I think, has the honor of being the only actual NYU degree holder on the panel. I'm sort of an imposter, and I don't think Scott or Jingjing have spent time here. Okay, so we'll give May 11 minutes instead of 10 in her prepared remarks. And the way that we'd like to structure it is to have each panelist will speak for about 10 minutes. They'll talk about what is the main sort of supply chain problem that they're seeking to address through their work, what kind of tools and methods they use in order to address it, and then, sort of kind of what works and what doesn't work. After that, we're going to transition to sort of a moderated Q&A session. So if people have questions, please use the Q&A button at least it's on the bottom of my Zoom screen, to type them in, and I will be monitoring them kind of as we go along and picking questions to ask as we move into the moderated discussion. So we're going to start with Scott, who, through his work with WRC and probably even before that, has spent at this point, I think we can say decades, working on addressing the labor abuses in the global apparel industry primarily, which has taken him to all corners of the world. And they have a very sort of unique model in trying to address this. So hopefully he'll give us a little insight into kind of what he's been doing for the past few decades. And I know more recently he's become quite active, or spending a good deal of time, like many of us, on what's going on in Xinjiang and different enforcement strategies that have happened there. So I'm going to turn it over to Scott for about 10 minutes.
Aaron, thanks so much, and very good to be with all of you this morning. The Worker Rights Consortium is a labor rights monitoring organization. We conduct investigations primarily in garment factories around the world to assess labor practices in those factories relative to applicable standards, usually the national law of the country in question. We do much of this work on behalf of colleges and universities, including NYU, that at the behest of student activists have put binding labor standards into the licensing agreements that they have with apparel brands like Nike, Adidas, and Under Armour. These licensing agreements are for the production of clothing with university names and logos, a lucrative business in the US consumer market. And what is virtually unique about these university labor codes is they are a matter of contractual obligation for the brands and retailers that hold these licenses. They're contractually obligated to ensure that certain labor standards are met in any factory they utilize, directly owned or in most cases contract factory, to make this particular category of product. But the WRC also, as an organization, works at factories and on labor issues far beyond the relatively small sphere of collegiate apparel production. And I want to talk about our experiences in that broader work and what they tell us about the challenges to labor rights compliance in global manufacturing supply chains and the ways that those challenges might be overcome. And the question we ask ourselves as we do that kind of analysis as an organization is, why is it that after a quarter century of well-known apparel brands and retailers promising to protect the human rights of the workers in their supply chains who make their clothes, why is it that despite relatively strong labor law on the books in most of the countries that export apparel, that labor conditions continue to be poor and substandard as the norm in tens of thousands of garment factories globally? Why is it that factory owners continue to, for example, illegally fire trade unionists largely with impunity? Why is it that wage theft remains not just common, but rampant? For example, we're going to put a report out soon about dozens of factories in the supply chains of major brands and retailers that have fired large numbers of workers during the pandemic and simply failed to pay them tens of millions of dollars in legally mandated severance. Why do these kinds of abuses remain persistent in the supply chains, despite the law on the books, despite the promises of brands and retailers? And I'm going to start with one important example, and then also talk about another vital one that Aaron mentioned, which is the human rights crisis in Xinjiang. What I want to talk first about is Bangladesh, now the second largest apparel producer globally, a country with about 3,000 garment factories and about 3 million workers, where through the early part of 2013, more than 2,000 workers lost their lives in dozens of entirely preventable fires and structural collapses in garment factories. And the important thing to understand about these disasters is that virtually every one happened in a factory that was not only subject to the national building code in Bangladesh, which is based on the Indian building code, which is based on the British building code, which is a perfectly fine building code that, if followed, would have prevented all of those disasters. That all of those disasters happened not just in factories subjected to that set of regulations, but also in factories that had been repeatedly monitored by well-known apparel brands and retailers who, under their own labor codes of conduct and monitoring programs, had sent auditors into those factories to assess the factory's performance in various categories of labor law compliance, including worker safety. Every disaster, whether it killed 5 workers or 50, or as in the case of the catastrophic Rana Plaza building collapse in 2013, 1,136, every factory repeatedly inspected by industry monitors, and yet the disasters continued year after year after year. And what we discovered through our own investigations and the work of other independent groups is that the brands and retailers never actually asked their auditors to look at the safety hazards that were killing workers. The 2 primary causes of mass fatality disasters in Bangladesh were the lack of proper fire exits, specifically the failure of factories to enclose stairwells in multi-story buildings to protect them from heat and smoke so that workers could walk down the stairwell out of the building in safety in the event of a fire on a lower floor. This is a fundamental principle of fire safety in every building code in the world. You cannot operate a multi-story building in the United States, for example, without such enclosed stairwells, and they're required in Bangladesh. Yet the auditors were never actually checking to see whether this vital safety provision had been made in these factories. The other cause, as in the case of Rana Plaza, of mass fatality disasters, was structural columns with inadequate strength to hold up the weight of the structure they were supporting. The auditors never looked at structural issues either. So year after year, mass fatality disaster after mass fatality disaster, and the brands and retailers, and I'm talking about the biggest brands and retailers in the world, even as they were telling labor rights organizations, their customers, the media, that they were engaging in diligent efforts to protect workers and address the safety problem in Bangladesh, never even asked the people they charged with inspecting the factories to examine the critical safety issues. Why? How is this possible? It only makes logical sense if you recognize that the purpose of the brands and retailers' codes of conduct and labor rights monitoring programs are not to protect the rights or the safety, for that matter, of workers. They are to protect the reputations of the brands and retailers, because the practical reality is that brands and retailers are able to achieve their goal of minimizing the cost of production in Bangladesh and other countries in which they produce, exactly because the factories they use don't have to obey the law. The brands and retailers put enormous price pressure on their contract suppliers, give them ample incentive to reduce labor costs and other production costs by ignoring applicable labor standards and other applicable standards. And then the brands and retailers reap the benefits of the success of factories in reducing labor costs through that illegal means. To the extent that those problems sometimes generate embarrassment for brands and retailers, they've adopted and implemented codes of conduct whose function is to create the appearance of labor rights due diligence by the brands and retailers, even as business as usual continues across the supply chain. And you could not ask for a more powerful illustration of that reality than what took place in Bangladesh from the early 2000s through 2013. Again, and I want to stress this point, they never even asked the inspectors to test whether there were proper fire exits in the factories. And this is the fundamental problem with the voluntary approach to addressing labor rights problems in global supply chains. There is a built-in conflict of interest. The things brands and retailers should be doing to improve working conditions and wages would raise their production costs. So there is a disincentive on the part of brands and retailers to actually impose their own standards and enforce them in an effective way. And when the decision that is made 1,000 times across the supply chain every day within the sourcing departments of brands and retailers between prioritizing labor rights and prioritizing cost control, I promise you in 99% of cases, it's the latter that wins out. And that is why we see these labor rights abuses persisting. It's important to talk very quickly about the role of the state. Why doesn't the government of Bangladesh enforce its own building code? Well, from the perspective of the government of Bangladesh, the situation looks a lot like it looks from the perspective of a factory owner, which is to say they understand that the reason these brands and retailers from Walmart to Adidas are in their country producing there is exactly because it's cheaper to do it there than it is elsewhere, exactly because they don't aggressively enforce their labor laws. And they believe, and they have a lot of evidence to back this up based on their experience with brands and retailers, that if they did in fact aggressively enforce their labor laws, that they would get a public pat on the back from the brands and retailers who would then assiduously set about relocating production to places that are cheaper because they're not regulating. So the state is constrained, just as the factory owners are constrained and incentivized to ignore labor rights. Now this brings us to the human rights crisis in the Xinjiang Uyghur Autonomous Region. What does this tell us about the labor rights policies and practices of brands and retailers? The worst human rights crisis taking place in the world today. It has been obvious since at least late 2018 that there was a massive problem of forced labor across the Uyghur region that was affecting the apparel and textile industry. The region is the source of roughly 20% of the apparel industry's global cotton supply, which means about 1 in 5 cotton garments sold in a store in the United States contains cotton from that region, with a high risk with respect to any given garment on any given day that it is tainted with forced labor. And yet until public pressure on the brands and retailers built to a high level in the early part of 2020, we're not aware of a single brand or retailer that had made a policy decision to take action to exit the region. Even though there's no way to do a meaningful labor rights inspection, given the risks that any worker would face for talking candidly about forced labor, even though the human rights abuses, forced labor specifically, are exhaustively documented, the brands and retailers didn't act until there was public pressure. Another illustration of the yawning gap between the labor rights rhetoric embedded in their codes of conduct and their public statements and the human rights reality in the real world across their supply chains. What's worked to address this regulatory gap are two things: public pressure on brands and retailers that convince them that there will be reputational costs for failing to take specific corrective actions to address worker rights. That's how, in the aftermath of the Rana Plaza building collapse, it was finally possible to get 200 plus brands and retailers to sign an enforceable agreement with labor unions to fix the factories in Bangladesh. And enormous progress has been made under that agreement, known as the Accord on Fire and Building Safety in Bangladesh. It's why in 2020, brands and retailers, under public pressure to do so, started to exit the Uyghur region. We need public pressure. We need to translate that public pressure into enforceable agreements between brands and people who represent the interests of workers, leaders of unions and worker organizations, to replace this failed voluntary model of self-regulation. And finally, beyond that, ultimately what we need is effective global regulation of labor. It cannot be done purely at the national level. We need, in particular, countries that are major net importers of manufactured goods to impose meaningful regulation on the conditions under which those goods are made by the companies in their supply chains who are importing those goods. And an important model for this is Section 307 of the US Tariff Act, which makes it illegal to import a product into the United States that is made with forced labor. And we could talk more about increasing efforts to enforce that provision and how it might serve as a broader model. And I'll stop there. Thank you.
That was an abrupt end. I didn't have my finger on the unmute button yet. Sorry for the delay.
I realized I was running over.
It's okay. You kept everyone engaged, or at least me. So big thank you to Scott for opening with that. There's a lot of threads in there, and I think you laid out quite nicely a lot of the issues that we're going to sort of delve into, right? About what are the levers we can pull and what really motivates companies, right? How effective is public pressure? How do you turn that into something that lasts beyond, you know, the days, weeks, or months that kind of everyone's excited about the New York Times article, so that we still care about workers in Bangladesh 3 years later, is something, you know, we'll delve into a bit more. And I think this idea of, you know, how do you avoid the sort of whack-a-mole of, you know, the multinationals are producing here, you know, you kind of get ramped up to sort of deal with that. And then, you know, a year later, they're producing somewhere else. You're kind of starting over. And this gets into the idea of global regulation. And, you know, I think we'll delve quite a bit into what does that actually look like and what does that actually mean and what sort of existing tools and potential tools are out there. So I just wanted to kind of tee those up as we transition to Zhang Jingjing. So as she will explain, you know, she focuses primarily on environmental issues, and I think communities affected by environmental issues. She has a very interesting background, which I hope she'll sort of elaborate on a little bit and give some really interesting perspective of having spent 10 years in China running a center that basically used the Chinese courts and Chinese law to address, you know, pollution and other environmental problems created by Chinese companies in China, right? And seeing how that legal system worked and did not work, and probably played a big role in shaping it as it evolved over the course of the last 20 years. And now has switched to focus to Chinese companies outside of China causing, I would guess, similar, you know, environmental and pollution related problems, and using the laws in some of those countries in order to try to achieve similar results. And so I'm not going to say too much more, and I'll turn it over to Jingjing, but I think one of those really interesting topics is, well, how much do these countries that China is in now and operating in now, you know, look like the China of the past? And sort of, you know, how do Chinese companies that have had this education within China, right, over the last 20 years, facing lawsuits by people like yourself, does that impact or even change how they behave once they go overseas and maybe are less subject to that kind of scrutiny and things like that? So a lot more than you can answer in 10 minutes. I know you already had a lot of other things planned to discuss. So I will turn it over to you, and I will let you know when you're about at the 8-minute mark. All right, thank you, Jacob.
Hi, this is Jingjing Zhang, and I'm a Chinese lawyer, still very proud of a Chinese lawyer. I have practiced in Chinese law for many years, and so now I'm going to, because we are talking about the supply chain, let me start the two cases around supply chain, the one old, one is new, and then I will give some comparison what the role China was and China is. So I'm going to start these two pieces of the news report, and if some people may recall, there was a campaign around Apple in 2011 in China, and we called this a toxic Apple, the Du Pingguo campaign. And Apple was blamed by Chinese environment organizations for turning a blind eye and to the suppliers' pollution and the damage of the workers' health in Suzhou and in many other cities in China. And Chinese NGOs got the opportunity to meet Apple. I don't know if they have met the CEO Cook, but they definitely met some very high managers and Apple. So that was quite successful campaign, and and combined with other efforts done by other NGOs, not only Chinese NGOs and other NGOs in US, in everywhere. And Apple has made this huge progress. And if you read this statement for the suppliers, Apple's suppliers responsibility report, and it claimed Apple is caring about the planet through their supply chain management. And I think that it gives us a very good example how the campaign initiated by NGO can work around Apple in China, Apple's operation in China. And now I'm going to talk about the new case around the supply chain, and that can tell where China is. When we talk about the Toxic Apple campaign, it was about China in 2011, and those suppliers are Chinese companies, the Apple suppliers. They are located in China, and now. We're seeing this case study. China has the world's biggest capacity to produce aluminum and aluminum. And since 2014, Indonesia, the traditional the country export bauxite to China. Indonesia banned the export of the unprocessed bauxite and that all. And then in 2016, Malaysia banned the export of the bauxite or the bauxite mining operation within Malaysia for 3 years. So that report, the picture showed this is that was happened in 2015 after the pollution caused by the bauxite mining in Malaysia's government banned the bauxite mining. So since the two biggest country which used to supply the bauxite to China banned bauxite export, now China turned to another continent. So that is West Africa, the Africa continent. I'm showing this picture. It's in Republic of Guinea, a tiny country in West Africa. It's a small country and very underdeveloped. It's one of the poorest country, 10 poorest country in the world, but it has reaches bauxite reserve. It has 1/3 of the bauxite reserve in one single country. And since 2014, Chinese companies shift the supply chain from Indonesia and Malaysia to this country and to the neighboring country. And when I visit there, I was standing on the mining road. I saw the dust and so many trucks running every day. It caused the dust, pollution, noise, pollution, safety issue. And there are many other problems associated with the bauxite mining, not only associated with Chinese investors bauxite project, and there are other Western company, Cohen and Rio Tinto, all these traditional mining multinationals are running their project in Guinea. And you see with the community lost their land, they have a water problem, and they are breathe the air with dust. And so they also human rights and environment issue associated with it. And can they express their concern to meet Chinese company CEOs as Chinese NGO had the opportunity to do? I seriously doubt it. But so they have a their way. You see the picture here. The NGO staff are organizing a village conference, and I was listening to her speech, and they are generating the information from community to use the public consultation process under their mining codes. And they are trying to get evidence to use their mining code to express their concern around the environment and social impact assessment. So they do have laws require company to consult with community to make the community development plan around the mining sites. But since the country it has a very weak rule of law and very weak enforcement of the all sorts of good laws, they have laws on the page, but the enforcement is weak. So the people, the community here haven't defined a very effective remedy yet. In the neighboring country, in Ghana, it has a little bit better condition, better rule of law. So the NGO has filed litigation and their constitutional court and against this bauxite mining operation. And you see the Chinese infrastructure for natural resource deals in Africa made a lot of suppliers in Africa for Chinese manufacturers. So one example, we mentioned this bauxite mining, and China has the biggest the producer smelter of the alumina and aluminum. And I need some companies here. Those companies all have their mining operation in the country, and the suppliers, either they are a subsidiary there or they are joint ventures in the country, and they all bring export bauxite and other minerals to China. And do we have any laws to regulate this supply chain? China has regulations. We do have some regulation, but not sufficient to manage the whole supply chain. So I want show some, it's not a very sophisticated research around the supply chains, more about China's overseas investment, because China's the BRI, Belt Road Initiative, and other investment policies have created so many suppliers for China in other continents, especially in the extractive industry. And so you see those administrative measures, they are regulations, they are laws, but they are not sufficient to regulate along the Chinese manufacturers' supply chains. And especially we don't have any requirement on the environment impact and social impact assessment along the supply chain, and we don't have an environment impact assessment associated with outbound investment management. And you can find some industry policies, like one of the mining association, Chinese Mining Association, did make this Chinese due diligence guidance for the responsible mining supply chains. But that is only one mining business association made policy, and they are not laws, so they cannot pose any legal consequences and liabilities to Chinese company if those Chinese companies do not follow those guidance and the policies. There's no legal consequences, and there's no pressures put on the Chinese the company's headquarters. And we do have some corporate ESG data disclosure regulations, but that all those regulations just limited to Chinese companies' operation within China's territory. if those Chinese companies have the suppliers beyond China's borders, those regulations cannot expand to those suppliers. So that is a big a problem issue around Chinese corporations, ESG, the environment, social and governance data disclosure requirement, and those Chinese companies have many Chinese SOE. They have heavily investing in other continent, other countries, other jurisdictions, but they do not have any requirement to report those investments, though their subsidiaries in other countries for their environment, social and governance disclosure, data disclosure. And I want to share some good, very exciting progress in EU. The reason I'm showing is because EU has just China signed this investment agreement, and it could put pressure on Chinese companies, because China Chinese company still will continue investing in EU, and their suppliers, the environment and the social conduct along the Chinese companies' supply chain will have to report to under EU's binding supply chain law. And you see, the EU Parliament just passed the legislative initiative report in March 10th, and so the EU is planning to make this binding supply chain law, and it will affect the Chinese companies, because the EU due diligence rules would obligate companies to identify, address, and remediate aspects of their value chain or operations, direct or indirect business relations, investment chains. So that set up a very strict requirement on the on Chinese company. If they are planning to continue their operation in EU and export products to EU, they were subject to this very strong supply chain law. So that gave a good.
Just 1 minute left, sorry.
Okay, so yeah, I will finish. I only have the last slide to show. You see so many legislative progress in EU, and since we are living in this globalized environment, all those legislation will affect Chinese companies. And so that's just my last slide. Do we have the supply chain law? No, in China, we don't have yet. But there's some good signal we found from China's recent release, the 14th five-year plan. And China is planning to make this outbound investment legislation, which will affect China's supplying and the Chinese company suppliers. And China is promoting construction of the Green Silk Road. And you see all those very good expression in this 5-year plan. But we don't see any substantial plan around supply chain. And we see this rule I want to mention is the rules on the counteracting unjustified extraterritorial application of the foreign legislation and other measures. It is a new regulation issued by Minister of the Commerce. So my question actually I hasn't been answered. I'm still thinking about when EU's binding on supplying law go effective, and when that law is being used on the Chinese company. China has a counter this rules, the countermeasure. By using these new rules. And so we didn't see any substantial progress on the supply chain, but we saw this countermeasure to any the kind of legislation like the EU's new binding supply law. So that is all. I just give the very quick my own experience and my analysis on this new legislative progress in other countries, and to show how China should and China hasn't make this supply chain regulation yet. So that's my talk.
Okay, thank you, Jingjing. So you covered a lot of ground in a short amount of time and give us a lot of things to come back to. I have one very quick question before we move on to May. I mean, I think a lot of what Scott talked about, right, is these sort of, how do you use sort of consumer pressure, right, in the home country, right? The fact that Americans might be very, taken aback by seeing a building collapse and workers dying, right? Maybe environmental pollution or something like that. What is your sense, having lived in China, having lived in America, do you view China as sort of moving in the same direction? I mean, if there was something in a Chinese newspaper and they saw that, in a factory in Cambodia, the factory had collapsed and workers died while they were making, something to export to China that's in every person's home. Would you expect a similar, put aside, whether makes it into the media or not, but, assuming it's circulating on Weibo and WeChat, I mean, do you see kind of similar public concern about human rights violations abroad, or do you not see that developing in any similar way? Basic question is, the way that, Scott talked about Americans having a certain reaction, to human rights violations that happen in the supply chain overseas that make goods, for the American home or the American consumer. Have you ever seen something similar in China, or do you expect that they might read about or see, let's just say a factory collapsed in Cambodia that was making, whatever, water purifiers that Chinese all have in their home, some kind of similar reaction, or do you see no signs of that?
I haven't seen yet. That worried me a lot because you see the firewall just creates two different parallel. I think the world within the firewall within China, every reports on news reports and or other research on the China's BRI, the outbound investment supply chain. Very good and very positive, and you didn't see much the news on the the water pollution in Guinea and land grabbing. The people really got all the troubles around the mining site. You didn't see that report in Chinese. So that could, if there's no facts provide to Chinese audience and Chinese consumer, they are not aware, and there's no way for them to have the empathy on the communities. They have been there. The Chinese community, Chinese consumer, they suffered pollution. They're living around the factory. They know the condition. But if they cannot read those news reports from Africa, from Latin America, and which report the facts to Chinese audience, there won't be a consumer pressure on the Chinese companies.
Right. So that's a point of, how do they even find out about it with the firewall and things like that? Okay, so we are going to take kind of a step back, or I think for a little higher up view, and transition to May, Professor Nguyen. And she is going to discuss with us her view on how mediation can sort of be used potentially to resolve some of these issues that we've been discussing.
Great. Can you guys hear me?
Yes?
Okay, great. Okay, so hi everyone. It's always a great pleasure to be back at USALI, especially today in the company of great advocates like Jingjing and Scott and Aaron on this issue of supply chain and human rights. So my presentation is very much a part of the continuum from Scott's and Xinjiang's work that we've heard so far. So we talk about some private regulations, some the law of host states, and some of the challenges that advocates faced. And what I want to explore is a particular form of informal dispute resolution. And what I call state-encouraged mediation. And the state here refers to the host state, where supply chain activities and therefore the alleged harms occur. So this mediation would happen in host states, sponsored, encouraged by the host state. So I want to unpack this in 3 layers. First, what are the background conditions that would make this even a viable model? And second, what exactly is state-encouraged mediation, and how is it different from, quote, regular mediation that we've seen elsewhere? And finally, what are the potentials and pitfalls that have to be addressed to make it viable? So let's talk about the background first. So you've already heard from Scott and Xinjiang about the myriads of challenges that advocates face when litigating and dealing with supply chain abuses. What I want to focus on is the interest of the host state itself. And acknowledging that a host state is not a monolithic entity. That said, at least for the cluster of countries that I have been looking at, that is Cambodia, Vietnam, China, there appears to be this overarching desire to maintain a balance between having a stable business environment and minimizing the social disorder that would disrupt the economy. In Vietnam, for example, these metrics for provincial growth, provincial GDP, social harmony are built directly into the promotion criteria for local bureaucrats. And when workers are out in the street protesting, they are not working. So this may give some openings for a conversion of interest among the actors in the host states, the companies that want their business to go on, and some workers who prefer a more immediate, even if not optimal relief. And the salient word here is some workers, some plaintiff. And I'll put a pin on that to return to. So what exactly does state-encouraged, state-sponsored mediation look like? And how is it different from just regular mediation? Now, mediation, as we think of in the US, is of course private-led, subject to the will of the parties with the aid of a neutral third party. The state is generally not involved unless an enforcement issue surfaces in the back end. Now, mediation is of course not new in any of the host states that I mentioned. China, of course, had a long history of mediation that takes many forms, from the lowest level of neighborhood mediation by a respected elder to the so-called grand mediation that integrates local and administrative processes with the judicial system. In the context of supply chains, we might say that Western mediation doesn't involve the host state enough to be effective, whereas the existing mediation mechanism in host states like China have too much state deference, whether institutionalized or not, such that the parties suffering the harms are subjected to even more acute inequalities of arms. So if we normally think of regular mediation and its associated mechanism, if we think of those to happen in the shadow of the law, at least in the language of US legalese, an apt metaphor for state-encouraged mediation, maybe to borrow Justice Douglas' penumbra theory in constitutional law. So we're leaning here not on the shadow of the host state's laws, for reasons that we've learned from Scott and Xinjiang, but on a penumbra of public and private interests to cobble together a bunch of shadows in hope for something that might work for the plaintiff that desire this kind of more immediate processes. And the degree of host state involvement is highly contextualized based on capacity, grip of control, central-local coordination, among other things. Now, at least in Vietnam at the current moment, local bureaucrats have played outsized roles in managing some of the disputes that resulted from the pandemic shutdowns in the last year. So I only have a few minutes. So in the interest of time, I want to move on to the final parts and focus on the pitfalls of mediation. We all know the advantages, but are there ways to deal with some of the magnified downsides? And I will just touch on some of the potential safeguards that have been implemented in some other contexts that may be helpful here. So one idea is to require investing foreign companies to put up upfront funds to cover representation and settlement. This is modeled after the so-called oil spill funds from the environmental law context, as well as the financial assistance funds maintained by the Permanent Court of Arbitration to assist less wealthy claimants. Another thought is to build a roster of mediators that each side has some says in selecting. Vietnam, for example, has recently established a mediation body in anticipation of the signing of the Singapore Convention, which is the mediation counterpart to the New York Convention for arbitration. The overarching theme, I think, is that there should be some space to make a procedural intervention for some stakeholders who may prefer immediate relief to a longer advocacy process, taking cognizance of the risk and pitfall involved. And there is, of course, a very real risk of cannibalizations of systemic change. Nonetheless, in this already suboptimal war of supply chain governance, a pluralist model of dispute resolution that offers options, to me, is still worth exploring. And one very final thought that I want to leave you with is to draw a connection between the persistent human rights problems in supply chains and the ongoing rising terrifying hate that the Asian diasporas in the US and elsewhere are confronted with. Now, at first blush, these two things don't seem to have a lot in common, but I think the longings are very much the same. That is the right to be seen as equal, the right not to be dehumanized as others. And some of the ills that persist in supply chains, wage theft, workplace safety, access to justice, are the very same ills experienced by vulnerable populations here. And the social transformation that is coming through discourse and change on anti-racism is giving me some hope that they will also, like pebbles dropped into the water, create far-reaching effects on supply chain practices. Thank you.
All right. Thank you to May for discussing and sharing this understanding about using mediation as a means to kind of resolve where there might be sort of shared mutual interest. I have a question. I mean, one thing that just sort of triggered in my head as you were speaking and thinking about Scott's talk is, you know, does it really depend on what type of labor abuse we're talking about, right? So, for instance, it seems compelling to say, sure, if workers are on the street, you know, they're not producing, right? It's going to hurt business, it's going to hurt tax revenue, it's bad for the local government that has a protest on its hands. You know, the workers want to get, everyone sort of has an interest in them going back to work, right? Maybe that model sounds quite compelling. But if you take something like where Scott is describing in Rana Plaza, that, you know, the workers are in an unsafe building, right? And, you know, production is continuing and the local government isn't dealing with anything right then. You know, how can we sort of get at that? Or, you know, does mediation kind of limit us to where you have an open dispute and the workers have already kind of made their voice known and raised the complaint and exercised leverage? So it's not really preventive, it's only a dispute resolution technique.
Mute myself. Yeah, no, that's a good point. It very might well be so that it is cabineted to a certain situation that can facilitate this model. Yeah, I'd love to hear Scott's thoughts on this and Jingjing's too on whether this is just purely an academic exercise or if you think that there's actually some potentials here in your on the ground work.
Okay, well, let's come back to that because I think it ties into a bigger question. And, you know, I think the conclusion I've come to in the last 15 years is there's no one tool to fix everything. And, you know, not suggesting that your proposal should have fixed every single labor problem in the supply chain. If we could deal with just disputes and resolving those quickly, that would be a pretty big step forward. So we're going to transition into the Q&A. Given the Zoom, limitations and format and whatnot, we're going to encourage people, to the extent you have questions, to type them into the Q&A, and then I will sort of monitor it and do my best to ask them. We will make one exception to this for someone who is undoubtedly exceptional. Jerry Cohen, I believe, is with us, and we're going to allow him to sort of kick off the discussion. Jerry, are you able to hear and able to speak? Have you been unmuted?
I have heard every word with pleasure.
Perfect.
Can you hear me?
Yes, we can.
Oh, wonderful. Well, I'm delighted to take part and benefit from this program. I congratulate the U.S. Asia Law Institute and Catherine Wilhelm for organizing it. And it's a wonderful tribute to Tim Gillette. Tim was my student, a wonderful one. He was my law firm colleague. I got him to teach part-time at NYU before I got to NYU. And he wrote prolifically, and he followed the maxim of Chairman Mao to walk on two legs. On the one hand, he wrote some groundbreaking articles about economic law, enhancing China's cooperation with the world in business. At the same time, he took at least an equal interest in the development of human rights in China. And he wrote some wonderful pieces about Chinese legislation and practice in the legal profession and the beginnings of the oppression of the Chinese people. Today's program combines the two in an imaginative, highly informative way. And it's opened my eyes to a fuller appreciation of the complexity of these problems. And I want to congratulate Aaron and the three speakers, and I look forward to the discussion. Now, it seems to me that we have to think best how to persuade China, the People's Republic of China, the government, and how to inform the people who have restricted access to information, as has been pointed out, to cooperate with the world, and how to get the other countries not merely to try to deal with China on an individual bilateral basis, but inevitably to forge the kind of international cooperation that's essential to persuade China to improve prospects for protecting the environment, protecting human rights, and promoting China's trade and investment with the world. And China is faced with this problem. If the Netherlands imposes sanctions or restrictions, should China react by countermeasures, or should China react by cooperation and greater appreciation for the reasons that the Netherlands feels forced to act? And can the Netherlands' actions be effective without the cooperation of the European community and the other liberal democracies that are important economic powers? So in the end, international cooperation is the key. But how to get it? When you look at China's record in the International Labor Organization, or you look at the problems of the foreign countries trying to deal with corrupt practices in dealing with China, these are enormous challenges. And I look forward to the next hour of discussion in the hope that I have provoked some responses. Thank you.
Right. Thank you to Jerry. Always great to hear from you, even though I can see your video, which I'm a little disappointed about. But that's a perfect segue into how I kind of wanted to start it off, to just put one more thing on the table. There he is, as if we didn't have enough already. But, I think we've talked about sort of two, I would say, buckets, right, of responses, right? We've talked about things that can be done in, let's call it the sort of, let's just use the United States as an example, right? The sort of consumer-based country, right, or the receiving country at the end of the supply chain, right? So the US or Europe or maybe China, right? And we've talked about, right, so within that realm, you have the consumer pressure and what that can generate, right? You might have tariffs and what pressure that can generate, right? You can't bring the goods into the country. We have litigation within those countries against the multinationals that Xinjiang talked about is happening in the EU, for instance. Then you have sort of what happens in the host country, right? Or the site of production. And we talked about the myriad of problems that exist, right? Corruption, weak enforcement, government might, their own interests might be aligned with what, low labor standards and continuing cheap production, right? But some of the possible tools to use there again, or perhaps using the legal system, whatever its limitations are, like Xinjiang talked about, right? The lawsuits in these African nations. May is talking about mediation within these host countries as a means to resolve these conflicts. And so there's a lot to unpack there. And I'm just going to put the last thing on the table that Jerry has raised, which is international, right? So we talked about the host country, talked about the sort of market country, and now at the international level, right? And this is something Scott sort of spoke to as well. And I think there's two ways to think about, international, right? There's kind of the, what happens in the, on some level talking about, litigation in the EU or tariffs by the EU for what happens abroad is already a sort of kind of international, mechanism and law enforcement structure. But I think what Jerry's hinting at is things like the ILO, right? So you have ILO conventions. We've had a discussion there's been a discussion since I've got involved in this field about maybe an ILO convention on supply chains that, as far as I understand, has not gone too far. Right, we have these United Nations Ruggie principles on business and human rights. So there's a lot of stuff out there, right, that attempts to regulate, what happens internationally. And so, is there any promise there? Should we be investing in that? Should we be hopeful? Is it only ever going to be as good as whatever domestic mechanisms are set up? And so maybe it's a waste of time. I'll start off with Scott, because I think probably in your experience, you've been part of a lot of these conversations. You've, seen how these turn into reality or don't turn into reality. I'm curious as to your take on that. Is there hope for, what role is the ILO playing, the UN, any of these, and is there hope there?
I mean, the fundamental problem with the role of those international institutions in the context of labor practices and supply chains is the lack of any meaningful enforcement power. And the ILO conventions have value to the extent that they set a standard that many brands and retailers have at least officially and rhetorically embraced, which then makes those standards a lever that advocates can use in their broader efforts to hold corporations accountable by pointing out that the abuses they as advocates are describing are in fact violations of the very standards brand or retailer A, B, or C has claimed to uphold. But beyond that, there's no value because there's no enforcement power. The ILO has no ability to take action, certainly not vis-a-vis any private entity. I mean, to the extent the ILO has any influence over what happens in the real world beyond the mere promulgation of standards, it can cajole countries, not terribly effectively historically, around their own decisions about what should and shouldn't be in their laws. But in terms of the ILO's potential effect on any private actor, it's extremely weak. I mean, you do have the so-called Better Work Program, which, as people probably know, is a joint endeavor of the ILO and the International Finance Corporation. That's as close as the ILO's gotten to some form of regulation. But again, if you look at that program, what it doesn't have is any enforcement power vis-a-vis what brands and retailers do.
So what about at the state level? So one thing that the ILO does do is, right, they have their committee of experts, right? So you talked about trade unions and freedom of association. So countries that sign the convention, it's a bit more complex, but on some level can be reviewed every few years by an ILO committee. Are you living up to the freedom of association convention? And they say complaint is filed. The government says, no, we're doing a great job. The experts say, well, give us more information. You should be doing a better job. Has that process produced meaningful results in your view?
Again, it creates tools that can be used by unions and advocates. And the work of the committees is helpful. The interpretation of the meaning of the conventions, particularly in the context, in our experience of right to organize, freedom of association, because it's possible, again, to point to a committee decision about how a particular right needs to be respected in practice, in making the case that a particular action by an employer is a violation of principle. And in the context of a fight with a factory owner, with a brand, over whether there's a violation, and if so, what the proper remedies are, being able to refer to that authoritative position, again, in the context of a set of standards the brand itself has claimed to uphold, that gives you something. But again, it's the standard that's of value. It still has to be turned into an effective lever by outside advocates because the ILO itself is not in a position to enforce.
Right. Xinjiang, what about in the environmental space? Are there any international regulations or use of, the business and human rights principles that have been meaningful in curbing or addressing what companies do in the environmental space?
Hi, Jerry. Thank you for your challenging questions. And we are facing all sorts of problems. You asking how can we solve it? And at the international level, I do think I have been always optimistic, which is sustain my work. I think at the international level, I do think we still have opportunities. We can pressure or invite China to join. One example is I mentioned the EU, this new regulation on the supply chain, which definitely will give pressure on the Chinese companies. So we should not forget America, North America, and the EU are still Chinese companies invested country, and China have been heavily invest in Canada, in US, in EU. So if we can raise the bar here in US and in EU, that will require Chinese company to change their business conduct. Like the EU, if that law passed this year, and it will put pressure on the China and not the supply chain or the reparation, direct and indirect business relations, investment chain. So you suppose we have a very strict requirement from EU and the US, ask a Chinese company report, disclose the conduct from their investment in Africa. That will set up a very high bar on Chinese companies. So that is one thing, the regional cooperation between US and EU to raise the bar on those multinationals disclosure standard. And that is one. I think another good example is UN right now is making this binding binding laws, treaties on the business and human rights on the multinationals. So that is ongoing process. We already saw this zero draft, and it's led by the Ecuadorian delegation and UN Human Rights Council, and the process of this drafting binding laws on the multinational is a good example how the international laws can work. And China joined that negotiation, even though China expressed the rejection on the extraterritorial obligation. And that is, China has always been keeping that position. The human rights issue is an internal business. Any country's internal business, and China will take care of the human rights issue in its territory. And so it always clearly express the objection on the extraterritorial obligation. But it's a global trend. If we can bring all the pressure from this liberal world and to China, I don't think China by itself can change, can rewrite the global order by itself. And on the people's level and the community level, people don't like Chinese companies' way to conduct business in their neighborhood. So that is also very strong strengths we have, and advocates, human rights and environment advocates have, because we are working with community, working for the community. They don't like the Chinese companies. We bring their business conduct model from China to their neighborhood and pollute their the environment and damage their lands, and they don't like it. And so that they deny better business model. And we saw Apple provide a good example, not perfect, and some Western-based multinationals, and they provide a better business model conduct than the Chinese company. That is what the strengths we can use from the international level to the bottom community level. We have supporters. We have the space to work on around this issue.
Right. So I wanted to put one more thing on the table and kind of ask Scott to talk a little bit about the Bangladesh Accord, which you brought up. And just for those who aren't familiar with it, so, Scott described how Rana Plaza, collapsed, I think, in 2013, right? The deaths that resulted created quite a uproar. They put into place this accord, which at its most basic elements, the brands agreed to certain standards. There was, I believe, an enforceable arbitration provision, although half the companies set up the alliance that didn't even have the enforceable arbitration. But at the time, at least as I remember it, and I think it's still often discussed as kind of the gold standard of, probably the best you can get to come out of, this kind of tragedy and turn it into something positive moving forward. And I'd like the report on where are we today? Why has, my understanding is it's kind of not what it used to be, and why is that? And then thinking forward to something like Xinjiang, where, all right, we're all very concerned about it today. How do we make sure in 5 years that we're still, we've put in place something that will last? Kick it over to you.
Well, the key departure that the accord represented was to make the commitments of brands and retailers, which were longstanding and effective, binding instead of purely voluntary. And most importantly, it obligated brands and retailers to stop doing business with any factory that refused to carry out a set of safety improvements necessary to eliminate deadly hazards. It's worth noting, when the accord did its first round of inspections across 1,600 factories, it didn't find a single factory with proper fire exits. That's after 15 years of corporate codes of conduct, if you want to understand just how abject a failure of voluntary CSR has been across the apparel supply chain. It had other critical provisions, including obligating brands and retailers not to squeeze suppliers so aggressively on price that they couldn't afford those renovations. But the obligation to stop using a factory that an independent body determined was unsafe was a radical change from the norm, because the brand and retailer had to stop doing business with that factory, even if it didn't want to, even if it wasn't convenient. And that created enormous positive incentive for factories to actually undergo the renovations. And that's why there's been, and I mean this literally, a concrete transformation of the physical infrastructure of the Bangladesh garment industry. Most of the factories have functioning fire exits and closed stairwells. 36 buildings were closed because they were at risk of the same kind of massive structural collapse that occurred at Rana Plaza. This is unprecedented in the global apparel supply chain, and it was a function of the binding nature of the agreement. You referenced an arbitration mechanism. There was one to address disputes over the brand's compliance with their commitments. There were a series of arbitration cases all of which were settled favorably for the labor side. And it basically worked, although lots of challenges, problems, weaknesses, particularly enforcement of the price provision. Right now, it's actually at a critical juncture. The government of Bangladesh, over time, developed great hostility toward the accord, essentially for two reasons. The government of Bangladesh, on issues related to the economy, is largely a wholly owned subsidiary of the apparel industry. And companies in general don't like to be regulated. So even though most of the leading factory owners will grudgingly acknowledge that the accord was effective and greatly improved the relationship of Bangladesh as a place to source, they're also hostile toward the regulators, and they caused the government to become hostile. The other big mistake the accord made was not to expand internationally at an earlier stage, because you have similar safety risks in multi-story apparel factories in Pakistan, in India, and it started to become a matter of national pride for leaders in Bangladesh that they were continuing to be singled out on this issue, even when they had improved to a point where they were demonstrably better than some key regional competitors. And so the combination of that nationalist resistance to the accord and an anti-regulatory ethos led to a lot of conflict. Without getting into great detail, given limited time, this precipitated a situation where to survive, the accord had to devolve certain powers to a nationally run body, which has not been as effective in our view. And now we're at a point where the extended accord agreement is about to expire in a couple of months, and there is a battle brewing between global and national level labor unions in Bangladesh and non-governmental organizations like ours and big brands and retailers about whether or not the agreement will be extended again and expanded to create an international framework that would support programs in other key countries where the safety risks are particularly high. And there's likely to be a public battle over this, because right now we're seeing a lot of resistance from the brands and retailers to a new enforceable agreement. Lots of enthusiasm for a new unenforceable agreement that will provide political cover at little cost, but not much enthusiasm for extending this model. And the outcome of that has big implications for what happens not just on safety, but on a range of labor rights issues broadly in the supply chain, because the model itself is at stake.
And so looking back, I mean, so what was it, right, that forced, compelled, got brands to agree to, if we take the assumption that no brand would voluntarily sign up for, an enforceable agreement without some significant pressure, what was the pressure and what was special about it in Bangladesh that the company today can then just look at Pakistan and say, no, we don't really, if you have the same risk, but they can say, we don't really think it's necessary. What was special about that moment?
It's one of those rare empirical questions in our complex world that has an extremely easy answer. 3 weeks of embarrassing media coverage about the unconscionability of what had happened when that building collapsed. It was the worst disaster in terms of deaths in any manufacturing facility in the human history of manufacturing. And the media covered it intensively and extensively in ways that were highly damaging to the reputations of major brands and retailers sourcing from the country. That's what drove brands and retailers to sign the agreement. Prior to that, 2 companies had signed prior to the collapse. One was a German retailer called Chibo. The other was PVH, which owns Calvin Klein and Tommy Hilfiger. And I tell people this story in more detail because it's an interesting one if there weren't limited time. But essentially, PVH signed because ABC News decided to do an expose on a factory fire that killed 29 people in 2010 at a factory producing for PVH. They went to Fashion Week. They confronted Tommy Hilfiger himself. He said a bunch of dumb things like, we don't even source from Bangladesh, which was not at all true. And PVH knew that ABC was going to run a big story on this. They had a couple of weeks before the story ran, and all of a sudden, they got very interested in negotiating an agreement. And that was the first company to sign the agreement that eventually became the Bangladesh Accord. Reputational pressure drives brand decision-making. Other than that, the only thing that really drives brand decision-making in a positive direction in our experience on human rights is actual governmental regulation.
Right. So this is a good sort of transition into, we have a bunch of questions that talk about another lever, right? And to what extent financial institutions, ESG standards, reporting requirements to stock exchanges on ESG compliance might be effective. And so just to one more kind of quick question to Scott. In thinking about reputation, I mean, if you could just try to unpack for us a little bit, so I'm Apple, I'm H&M, this thing hits the New York Times. What am I really concerned about? And is there empirical evidence to back it up? Is it my share price is going to drop? Is it that American consumers are actually less likely to go to H&M because they read about Rana Plaza? I don't know. I mean, do people not buy iPhones because they read about Foxconn?
Surely some of them. I mean, remember, and Apple's a good example of this, more so than many electronics companies, but in the apparel industry, branding is everything. I mean, this is an industry that is fueled by the willingness of a person to spend 3 times as much for a garment because a particular brand made it, 3 times more than the same garment without the brand name, exact same garment, same use value. What is it that causes people to spend what they spend on iPhones? It's how buying an iPhone makes them feel about themselves. Brands and retailers understand that is the primary value of their company, all the more so in fashion, but in electronics as well. And the concern is that over time, fewer people will buy the product, fewer people will be willing to spend as much for the product. So when Apple faced its acute public relations crisis around labor conditions in the supply chain, which if I recall correctly was 2010, 11. Does that sound right to you?
Yeah.
Right. So one thing it did was join the Fair Labor Association,
right,
which it's no longer a member of, by the way. But it was a member for a few years because that was part of its strategy to create the appearance that it was carrying out due diligence. But if you look at Apple's rhetoric around human rights over a span of 2 decades, what the company did versus what it promised to do, it's painfully clear. There's a tremendously valuable quote in one of the excellent New York Times pieces around the time of that crisis. I can't recall who the journalists were. David Barboza, I think, was one of them, who now has this thing called China Wire, which is also a useful publication. But he was quoting an Apple executive talking about how these labor rights abuses had persisted for years at Foxconn. And he said, we've known about this for years and have failed to address it. Of course, this was an ex-Apple executive. He said, imagine if Foxconn had been screwing up the screens of the phones. You think we would have let that go on for 4 years? And this is exactly the point. If Apple wants to fix something in its supply chain, it fixes it. If it isn't actually fixing something like abusive labor conditions, because it's chosen not to fix it. And this is true by and large of global corporations in general. They're getting exactly the conditions they choose.
Right. So that's interesting. I mean, I think that's my kind of gut response on, some of these questions about ESG standards that Elizabeth Donkerbort had asked in the Q&A, right? So the Hong Kong Stock Exchange, the one I'm most familiar with, right, has an ESG reporting requirement, right, to basically say if there's, either that they've addressed the issue or that there is no material risk of the issue arising. And I put it in the chat in the Q&A. I don't know if all of you can see it. In the case that I was working on in Saipan, right, which is a Commonwealth of the United States, right, located in the Pacific. There was a company in Hong Kong, sort of Chinese owned, that was building a casino there. And they hired a bunch of Chinese construction firms to do the building. And I just found it very interesting to look at the ESG reports that were filed both by the casino, who was supposed to look down its supply chain, as well as the actual construction firm, as to, right, what they wrote about forced labor, what they wrote about health and safety conditions. And to make a very long story short, you have well-documented instances of worker injuries, potential forced labor, withholding of passports, a lawsuit, alleging forced labor, of course, none of which gets even mentioned in any of the ESG reports. And certainly they don't check the box to say that they think there's any material risk of forced labor in their supply chain, even having been sued for engaging in forced labor. And William Nee, who used to be at Amnesty International, kind of wrote this all out in a piece for the Hong Kong Free Press, which I put the link up on there. So I think it kind of comes back to the same thing. What's the remedy? It seems like not a bad transparency tool, right, to require reporting, but what's going to be the remedy if you find out that there's an obvious risk of forced labor and you check the box that says no forced labor. So I think it kind of, follows the same sort of pattern as the other things we talked about, in my view. And I think there was a big debate about making, much stronger penalties as they revised the ESG standards in Hong Kong. And my sort of understanding from the periphery of being involved with people in that working group is it didn't go very far. And they kind of revised the standards without putting in very meaningful, enforcement of them. I don't know, has anyone seen more promising things like an ESG investment right now? I can put my IRA into only ESG stocks and funds. Does Reebok care that, they're not being certified as an ESG company?
Well, I would say that we, in the US, at least in the last few years, there has been this trend of lawsuit based on consumer protection law, suing for, I guess, among other cause of action, misstatement and breach of contract by the consumer based on these very fact patterns that you just described, Aaron. And in a lot of these cases so far, they have all been dismissed on the premise that corporate social responsibility is aspirational in nature and it's not really part of an enforceable contract. The Walmart litigation, I think, was the one that got the furthest, but that got dismissed. So that's on that front. And then the one thing I do want to touch on is, and I don't know if they're in the audience today, but there's an ongoing effort at the American Bar Association, the business law section, in drafting model supply chain contracts that companies that are willing can then adopt and modify to include in their supply chains agreement. And that lays out a host of remedies and a host of factors on if the companies are willing. That's the key phrase. How would they even implement this? So another ongoing effort to try to get to the point of a remedy.
Yeah, and I just wanted to, a couple of people have asked in the Q&A if you want to get to at some point about how you put pressure on governments as opposed to private entities, and happy to speak to that when we get to that appropriate time.
Yeah, one more just on the financing, and maybe Xinjiang, in looking at these projects in Africa, for instance, right? I don't know how, a lot of them, I guess, with Chinese companies are perhaps funded by Chinese banks. There's probably also projects going on that are funded by the World Bank, IFC, right? Who all have, to different degrees, codes of conduct about you talked about environmental impact assessments that need to be performed, right? Social indicators, which often include labor-related things. So how do you have any experience you could speak about, do those World Bank requirements on projects produce meaningful protections? Is that being replicated at all with the Chinese banks and the Chinese context? If you could speak to that, I think that would be helpful in rounding out this picture of, how the financer might be a leverage point or not in this puzzle.
Yes, the financiers' role is have been mentioned. The Chinese financiers' role have been mentioned and has been tried by various international NGOs, but it's extremely difficult to work on Chinese financiers. Those Chinese financiers, banks are extremely non-transparent. So the loans that I mentioned, those loans under China's infrastructure for natural resource deals in Africa, you couldn't find them. They're not in the public domain. You couldn't request Chinese banks to release the information because they're not considered as governmental information. Those loan agreement are not subject to China's open governmental information regulation. You couldn't take any action. Extremely non-transparent. Those Chinese loan agreement to Africa, any other Chinese investment receiving countries. But I do see some potential there. I hope Chinese banks can follow the example from only one bank located in China, Asian Infrastructure Industry Bank, and has set up a very clear social and environmental social safeguard and set up this bank's grievance mechanism, even though it hasn't been used by community yet. We haven't seen any cases yet, but it sets up a good example how Chinese bank, even though AIIB never considered it, Jimmy Qin never said it's a Chinese bank. It's a multinational, natural bank, and it always said that it's not Chinese bank, but it's located in China. No one knows. That gave a good example to show Chinese financiers can do better and can learn from our bank. And the same bauxite investment in similar sector in Guinea. I saw this complaint filed to IFC because IFC has this mechanism, receive communities complaint. So NGOs represent community in Guinea file complaint, and it has been accepted by the IFC on the inspection panel. And while on the China finance investment in Guinea, we don't know what arrangement is, and there's a China-Guinea economic cooperation framework agreement is not transparent. We couldn't get it. I requested for 5 times, and we didn't get any information. We were rejected, and my partner filed request in Guinea, and the government released that agreement. So we didn't know what the agreement between these two countries and 20 billion deals. We didn't know who involved and which Chinese company got a piece of pie and which Chinese bank signed agreement with the government, the host country government. We don't know because it's not publicly available, the agreement. So it's extremely difficult working on the Chinese financiers, and but Chinese financiers could do better, and we still need to put pressure on those Chinese banks and other Chinese financiers.
Right. So let's transition. I'll stick with you, Xinjiang. So we've had some questions about not just the multinationals, but how do we put pressure on governments to do better? And so starting with China, right? You talked about a lot of the things that make it hard for advocates, right? The firewall, the lack of transparency to get information. I guess you could think about China in 2 ways, right? One as a producer of goods, right? And also as a sort of consumer, right? As, going overseas and doing projects. In either way, what can be done to put pressure on the Chinese government? And Xinjiang, I know it might not be your area of expertise, but maybe to just make it very concrete, so for instance, right, the United States has imposed tariffs on things coming out of Xinjiang, right? They've imposed sanctions on Xinjiang government officials, right, in terms of travel and finance and whatnot. Do you expect that this will lead to some sort of change in China's policy? And if not, what might influence Chinese policies?
Based on my experience as Chinese, we don't like the name and shaming approach. I mean, we, the Chinese government, the Chinese people, and by nature that no one likes the criticism on your face. So Chinese people care about the face. And so you have to, get to know that the current regime, current government extremely care about the face, and because one of them, I think it's lacks of security itself, and so it care about criticism and don't like it. So if you directly criticize it, it will defend itself extremely. You see that example all these years after the current regime, after 2012. you see it happened. But that doesn't mean we don't have a way to work on the Chinese government in terms of the legislative or policy change. And you have to find the right timing, use its own vocabulary. And one example is for the 14th 5-year plan, you can see some good signal released by the Chinese government, and using that opportunity and to achieve the goal, like I said, China, the government expressed it will make the outbound investment law. So that gave us opportunity to put some good example, good practice as an example for China to consider. It cares about or at least make the pledge. China made the pledge on the climate. So you can combine other rights violation with crime together to convince Chinese lawmaker, policymaker to consider some recommendations for the policy and legislative change. So you have to understand China's own bureaucratic system and his own vocabulary in order to convince it. And so that is our homework, and we have to get to know this bureaucratic system in order to change it.
Right. So interesting. So I'm gonna, while we're on Xinjiang, maybe jump over to Scott. From your perspective, are the actions that have been taken to try to influence Chinese policy the correct ones? And have we seen, we talk about companies, perhaps withdrawing from Xinjiang. Have we seen any movement or positive indications that there might be change at the Chinese government policy level?
I mean, like corporations, governments don't experience moral epiphanies, right? It's all cost-benefit analysis. And, our analysis is that because of the way in which Xinjiang fits into the Chinese government's economic strategy nationally and regionally and globally, and because of the heavy dependence of key sectors in the region on the global market, there is very substantial potential economic leverage. WRC, the broader coalition we're part of working on this issue, we don't have, for the most part, the kind of expertise that would enable us to be very useful contributors to an analysis of how that pressure flows through thinking and decision making. I mean, we have people with deep expertise like Jerry and others who'll be much better positioned to comment on how that might unfold. But our read is that there is very substantial potential economic leverage, and we're just starting to see that applied. The question for our coalition is really two questions. As we begin to see the pressure move beyond apparel to the solar industry, to other sectors, one, is it possible to effectively make the Xinjiang Uyghur Autonomous Region a no-go zone for global commerce because of the human rights abuses? And then two, if that can be achieved, is that enough to convince decision makers within the Chinese government that a new human rights course is in the government's interest to pursue? If the answer to both of those questions is yes, then it's possible the economic pressure could have a profound impact on the human rights situation. If the answer to either of those questions is no, then it won't. I think there is a real chance to build that kind of economic leverage. I'm less knowledgeable about whether that will be enough to convince the Chinese government to change course.
Right. And so before I bring in May, because I want to hear her perspective from Southeast Asia, where, smaller countries, right, than China, which, perhaps are more vulnerable, right, to sort of, policy changes and trade changes. But from your perspective, Scott, I mean, I think you've lived through kind of debates about China and different trade provisions and most favored nation and joining the WTO and everything else. But you've also seen it in a lot of other countries, right? How do our free trade agreements, for instance, are those effective levers for enforcing labor rights? Could they be, or could they be, but they have not been? What is your take on how we should be using trade or these international sort of like trade rules to enforce labor?
I mean, they could be. Historically, they haven't been because they haven't been designed to do that. They've been designed to advance the interests of U.S. multinational corporations. It'll be interesting to see how the innovative labor rights provision of the USMCA that allows complaints to be brought against an importer in the US over labor rights abuses in a specific facility in Mexico. It'll be interesting to see as that mechanism is utilized by unions in Mexico in alliance with unions in the US, whether that has an impact. It may. I think that's the right model, holding importers responsible and accountable vis-a-vis what happens in specific workplaces overseas. This is the first such agreement that's ever existed. But I do want to make just one more general point. I mean, there's a limit to the degree to which any of us as Americans, if we're Americans, as Europeans, as consumers in Japan or wherever else, that we can do to influence the decisions of a sovereign government in China or in any other country. What we can do is hold our own corporations accountable. And our focus with respect to the human rights crisis in Xinjiang is about that. We need to hold corporations that sell goods in the US accountable for the ways in which they are complicit in, are abetting, and are profiting from forced labor and broader human rights abuses in that region. And that is something we have the ability to do. And that is what our trade agreements should do. They should hold our own corporations accountable for what they do within the territory of our trading partners.
Mm-hmm. And so, yeah, so I want to turn to May and kind of see it from, a Vietnam or Cambodia sort of perspective, right? How do US or EU trade policies, right, can those, or have they been effective at all for, influencing kind of corporate behavior? Really, I guess less corporate behavior. They're trying to really encourage, right, the host government to improve its standards usually. Right, it's not generally the model Scott's talking about. It's, can Malaysia or Vietnam, build up its domestic capacity to meet the ILO standards, for instance. And I was part of a process with TPP where, the ILO was sort of brought in I was in Malaysia, right, sitting there for a few weeks with the government, going through their domestic laws, trying to make sure that, all the categories of prohibited discrimination met what's in the ILO conventions and, changing their amendments to their forced labor law and trade union law, right? So that's one mechanism that perhaps, could be useful. But how do you see it, May?
Yeah, so, and as some of you have experience working directly with the Better Factories program in Cambodia, that is one clear instance where tying human rights issue directly to trade have demonstrable impact. And we saw that taper off as soon as the trade incentive expire.
Can you just say a little more about that for people who aren't familiar with the kind of case study, kind of what it was set up to achieve and how it unfolded?
Sure. So the Better Factories program was a framework that was tied to the, I think it was 1999, the multi-fiber trade agreement. It's a bilateral agreement between the Clinton administration and Cambodia. And that gave the ILO the right to set up an independence body to inspect and monitor Cambodian factories. In some ways that created sort of this rehabilitating environment for brands that has suffered from human rights name and shame, like Nike, to come to Cambodia to take part in this improving environment on the factory floors. But the agreement expired in 2005, I believe. And there have been a lot of reports and criticism on how the standard have been slipping since then. But to return to your questions about Southeast Asia, so we're in this interesting moment of two things happening at once. One is the restructuring of supply chains that we're seeing all over to reduce dependence on China. And so we see countries like Vietnam, Cambodia, and other smaller Southeast Asian nations and elsewhere trying to figure out how to capture these new market shares as companies and states trying to figure out how to diversify their supply chains. So now it could be a race to the bottom, as we've seen before, or it could be an opportunity for countries to build themselves up as part of a socially responsible, sustainable value chains. And I think that really depends on, as Scott and Xinjiang and you too, Aaron, have highlighted, that we need consumer awareness, worker advocacy, better global coordination, international coordination, to create this movement to prevent the risk of a race to the bottom. And the second thing is that, and my colleague Ben Heath at Temple is an expert on this, there's this tendency now for national securities and supply chains to collide. So a lot of talks about how chains that are deemed critical need to be onshore or reshore. And that creates further opportunities to destabilize this supply chain dynamic that has been in place. If human rights, labor issues can be advocated to be part of this national securities concerns, that open up further venue for the kind of advocacy that we're talking about today. And from the perspective of smaller countries like Vietnam, there has been a lot of discussions on what kind of branding countries like Vietnam want to give so that it can capture the sort of this value shifting in supply chains. Of course, it's in this geopolitical moment where it's also trying to hedge against China with the conflict in the South China Sea. So it has a lot of incentive to want to distinguish itself. And there's this ethos that Vietnam's international image is tied to its domestic survival interests. And so the more that Vietnam can be seen as a quote unquote good country, that has some implication for its national securities. So I think that all gave some hope for the fact that it might not be a race to the bottom, because economic interest is tied to its survival interests, especially in this sort of great competition moment that we're in.
So I want to try to play a fun game in honor of Catherine Wilhelm, who used to be at the Ford Foundation, and our previous executive director, Ira Belkin, who were at the Ford Foundation. Because I'm trying to think, so we've talked about, 10 different strategies, 10 different levers and tools. We've talked about their pros and cons and what's going to be effective and ineffective, and they all kind of fit together. So I'll start with Scott. And so, I'm the program director at, XYZ Foundation, right? I've already given your organization, $100, right? Full
$100? That's not going to.
Well, let's just say I have $200 to spend to make it easy, right? I've already given 100 to your organization, so that's covered.
Right.
But I have $100 to spend to work on global labor rights and supply chains, right? I could give it to lawyers in the US to bring cases. I could bring it to try to affect US government policy. I could train labor inspectors in Bangladesh. I could, try to root out corruption in the Bangladeshi government, right? There's a million different options. So you're sitting there with the checkbook, right? You can spend the $100 however you want to try to, let's just make it narrow, right? To improve labor conditions in Bangladesh. You've already paid the Workers' Rights Consortium. So how would you divide up that money? What is the most bang for your buck in your view?
It should go to labor unions. If we're talking about the garment sector or any other industrial sector, preferably led by women workers who make up the majority of those unions, you can look at what's happening in the battle against the coup in Burma and who's leading that fight. If you want to get a sense of the enormous difference that strong union leaders and strong union organizations can play, and if those kinds of organizations had 10 times or 100 times the resources they have, they might actually be able to accomplish something in terms of labor rights and supply chains too.
Okay, so seen as labor unions and sort of the political space they can come to capture as, having a ripple effect, they can influence domestic politics, they can influence government enforcement, protect their own rights. Good answer. I feel like you've been asked that question before. All right, Xinjiang, we're going to play the same game. So we've already fully funded your center at Maryland, so that's covered. You are now president of the foundation, and you have 100 million, whatever it is, to spend on improving environmental conditions, let's say in Africa, right, from these sort of corporate abuses and pollution and other bad impacts, right? You can give it to local lawyers in these African countries. You can give it to the environmental inspectors in those countries. You can give it to the AIIB to improve their environmental impact assessment standards. What is the best bang for your buck in terms of actually, reducing or correcting these environmental wrongs that happen?
Of course, I will give to the lawyers and local lawyers who are representing communities, and give to NGOs who are working with lawyers and for the communities. And I think the bar should be raised there for them to be more resistant to the harmful international investment, no matter from China, from other countries, and that is a capacity building for the local lawyers. And this is what I learned, I benefit when I was a lawyer litigator in China. And I learned from a lot of the resource. And so my capacity to use our own laws, Chinese laws, to sue polluters, to raise the awareness within China and change laws has been supported, benefit from those resources. So of course, I will give the money to the environmental human rights lawyers in Africa and NGOs there.
Okay. May, so we've already funded your research for the next 40 years. You can hire 10 research assistants every year, take as many field trips as you want, although in COVID, I guess we don't need a big budget for that. From where you sit, right, where would you, the foundation brings you in as an advisor, say, we don't like what's happening in Southeast Asia, all these labor problems, environmental problems. Should I be giving, let's take Vietnam maybe, right? I can give the money to the government inspectors there. I can give it to civil society there. I can try to change US trade policy towards Vietnam. We can give it to the ILO to do a review of their, labor standards on the books. Where would you put your money?
Yeah, so in some ways, this is an easy one for me. I would give money to create an indicator that has to do with human rights issue in supply chains. Because for Vietnam, that go directly to the incentives of local bureaucrats. Indicators like the World Bank doing business, and actually there's a local indicator that ranks provinces based on their GDP growth and governance, among other things. Those are directly incorporated into the promotion criteria of these provincial cadets. And so if there's can be a way to create one to address, to go directly to these issues and have them incorporated, that is to me one of the way to strike directly at the incentive of the local actors.
All right. So we have about 3 minutes left. I tried to sort of make that a closing statement for people. Is there anyone who wants to, I give you each 35 seconds to say something if there's something you want to add to close. We'll start with you, May. Anything you want to add before we wrap up?
Just, thanks everyone for this great panel. I learned a great deal from your on-the-ground practice. So enormous problem that we're facing. And we haven't had a lot of time to really dive into the exact sectors, I think, and there's a lot of idiosyncratic feature there that I think drive the remedy questions. So hopefully there'll be opportunities for that in the future.
All right. Jingjing, any last words?
Yes, I will take this opportunity to answer one audience question around the corporate private governance.
Just 30 seconds.
Okay, yeah. So the due diligence law is very necessary. I hope China can integrate the due diligence requirement to the outbound investment law, and the Chinese company need to improve the corporate governance regarding the human rights.
Okay.
That's my final remark.
Scott?
Corporations will never regulate themselves. If we want to change the behavior of corporations and global supply chains, we have to actually regulate them. because we're talking about cross-border regulation, we need new models to do that, but we know what real regulation looks like.
Jerry, I see you're still with us. Do you have anything you'd like to conclude with?
This was a terrific discussion. As I said, it opened my eyes. And the favorite song for a long time in China was "Tomorrow Will Be Even Better." Ming Tian Wei Gung Hao. And tomorrow's program closely relates to today's ethical dilemmas for those of us in the legal profession. Congratulations, Catherine, and to all the speakers.
Okay. Catherine, anything you'd like to say?
I want to thank you, Aaron, for helming such a really rich conversation. I especially liked your final question to everyone about where we should put our money, because this really makes it practical. And you don't have to be a foundation program officer with $1 million budget to actually have that question. You know, at the end of the year, when you're thinking about where you want to write your donation checks, as I hope everyone does to some extent, this is also very meaningful. Where does your money have impact? And as you say, which of these buttons is going to be the most effective one to push? And clearly, multiple buttons need to be pushed, but it does help to have some sense of which is most likely to have an effect in the moment. And in any given moment, it may be one more than another. I wanted to just, and also thank the panelists, the speakers, for your excellent contributions. It's been a fabulous conversation. I wanted to ask one more favor of each of you, is if you have any readings you would suggest for our audience that might go deeper into some of these themes that we've talked about, if just maybe one reading each of you, if you could share with us, and we'll put it on our webpage, on the same page where we promoted today's event. So if anybody wants to do some further reading to sort of get at some of the questions that perhaps you didn't have time to answer as fully as you would have liked, or maybe we didn't get to, that would be a way of addressing that. But thank you all so much. I've learned a lot today, and it's given me a lot to think about. And as Jerry ably said, we will follow up on some of these themes, but through a different lens tomorrow, when we go to the question of what are the ethical dilemmas that we all face if we are students of and scholars of China. So I hope to see many of you tomorrow. We start tomorrow at 10 a.m. rather than 9 a.m. I apologize if that seems confusing. And we'll also have it'll be another 2-hour panel. So see you tomorrow. Thank you, everyone, and goodbye.